Hi, I'm Debbie Moraes. This is Legal Matters, the program that's been designed to address the critical and sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. Today, another family topic, Medicaid planning. The goal, assistance for seniors and those who care about and plan for some long-term care. We've discussed estate planning, living wills, living trusts, power of attorney, health care directives. Along those lines, we'll be talking about those types of issues, but specifically, the cost of long-term care is often catastrophic for elderly, middle-class couples or individuals. So we want to cover that topic today. And first, we want to once again thank our legal counsel from Bazar Grasso Law Firm in East Providence, David Bazar. And today we have with us a special guest, attorney Larry Barron, who has extensive experience in this area. He represents Rhode Island and Mass residents for some 30-odd years. His firm counsels individuals, families, same-sex couples, and business owners in estate, special needs, asset protection, business succession, retirement tax, and charitable planning. Wow. So, welcome, and let's start with you, and perhaps the two of you can work in tandem as we had discussed. Before we start talking about nursing home care, which for Medicaid is for those with limited assets, some strategies and tactics work, some have changed, some can get you into trouble. Explain what Medicaid planning is before we start talking about what the strategies are.
Sure, Debbie.
Larry?
Debbie, so Medicaid is a government program that pays for long-term care in a skilled nursing facility. Under some circumstances, it also will pay for that same type of care at home. But it is lumped in with welfare programs, so it's right alongside the program that pays for food stamps, families, aid to families with dependent children. And so in order to qualify for Medicaid to pay for this long-term care, there is an asset test, which is pretty severe, and an income test.
Okay. And it is considered to be, Medicaid is considered for those who are, as you say, poor in some cases, but there are also many people who you work with who have some sizable assets, and that planning, while it's legal and you're going to go through those things, is it ever really ethical to move those assets around? Is that a fair thing to do?
Certainly. So again, it's unfortunate, without getting too political about it, it's unfortunate that this program is lumped in with the welfare programs, and yet we have all these middle-class people who have worked hard all their lives, and if you talk to them and you tell them that, well, no, you need to pay for this yourself, unless you make yourself look poor, there's some disappointment. Gee, I've worked hard all my life, set aside assets, pay my taxes every year. Why is there not a government program that pays for this? So, to answer your question about ethics, the regulations are set up so that, again, if you qualify by having a certain amount of assets, and the thresholds are in Rhode Island for a married couple, the way it works is this. They take a snapshot of the couple's assets as of the date that the institutionalized spouse, the one in the nursing home, is first institutionalized. They take a snapshot of the assets. They don't count certain assets, so the home is taken off the table. A lot of clients ask, well, am I going to lose my home to the nursing home? And the answer is no. The home is not counted as an asset. Interestingly, in Rhode Island, retirement accounts are not counted. In Massachusetts, they are counted as assets, but in Rhode Island, they're not counted. Everything else is up for grabs, and so we look at the assets, divide by 2. The healthy spouse, the spouse at home, is allowed to keep half of the assets up to about $120,000. Everything else is put on the institutionalized spouse's side, and then she must spend down until she only has $4,000 in her name.
And there are wonderful ways of doing it, not so wonderful ways that are outlawed and you can be penalized. Explain some of the ways. David, do you want to jump in here too?
Sure.
What some of the ways might be?
As I do that, I just want to just expand a little bit upon what Larry has already said, is that people, and my clients come to me, and I say hi to my clients out there because they know we've talked about these types of things many times. I've worked so hard, as Larry said, and I want to be able to pass things along to the next generation. I don't want my house to go back to the state, and I don't want to lose everything I've worked for. So that's why there are ways of doing this planning. And so to jump ahead to that a little bit, I've done this with Larry for many years, and it's changed over the years. When I first started, and probably different when you first started, you'd had a 3-year look-back window instead of 5. You could
Explain.
So when you give away assets, the snapshot that they take, they look back at a certain number of years and ask, have you given away any assets? And it used to be within the last 3 years, now it's within the last 5 years. And even after you went into the nursing home, we were able to say, okay, well, we can give away, as you might call it, a half a loaf, which was you could give away half of your assets, pay with the remaining half of your assets, so that the elimination period that you had, as Larry used to describe it, the cloud over your head, that you weren't eligible for Medicaid to pay, until that went away and the sunshine came out and could pay, you were able to do that with that type of planning. It's now changed. Larry's kept up with it, and so there's a lot of things that he can talk to and address on those
A good
issues.
segue, Larry.
Sure. So what David's talking about is what some people do to make themselves eligible, to make themselves qualify, as being poor, is to give assets away. And so the Medicaid folks are wise to that. And so there are rules that say if you give assets away within now 5 years of filing the application, you'll be disqualified for a certain period of time. And the way it works is they divide what they consider to be the average monthly nursing home cost. In Rhode Island, it's about $9,000. You divide that into how much you've given away. And so by way of example, if you've given away $90,000 to try to make yourself look eligible, divide 9 into 90, 10 months you'll be ineligible for. And before the regulations changed, the period of disqualification used to start when you gave it away. So if you know that within the next 2 months you're looking at a long-term nursing home stay, you might start giving away assets, knowing that the clock would start running right then and there. When the rules were changed during the Bush administration, not to be political, the disqualification period started when the institutionalized individual was otherwise eligible. That means that, A, they had to be already in the nursing home, and they had to already be down to the poverty level. So that meant that if you give away assets before you go in, you're going to be ineligible, but that period doesn't start running. So in this case, the 10 months wouldn't start running until they were in the nursing home and had only, in Rhode Island, $4,000 in their name. So for many of those people, it was cruel, because you're basically saying to the institutionalized individual, you need to go into a nursing home and hope that your family will pay during this period of disqualification.
What happens if you try to plan in advance? You're healthy, but you never know what's going to happen, so to speak. Do people come to you and start planning when they're young and healthy, because hopefully someday they'll get old and maybe not be so well? Do they come when they're young, healthy, or how do you deal with that versus when someone comes closer to 90 and then they might need to go in a nursing home in the next 5 years or so? How do you address that? What happens when someone comes in? How do you handle each of those kinds of clients?
The nature of the qualification is that these assets have to be gone. They have to be beyond your reach. And so in talking to most people, they come in, they're healthy, and they say, well, we want to make sure we're ready for the nursing home. I can say, okay, well, we can make you poor today. You're ready to give away all your assets to your kids. And then you're healthy, so we're likely to get past the 5 years. And of course, the answer is no. People worked hard all their life. They don't want to give away assets. So they're in a bit of a bind. So there are some techniques. For example, I said they don't count your home. But if you've got another piece of real estate, say a rental property that you have, we could put that into an irrevocable trust beyond their reach, keep a right to the income, the rents, the net rents that come in, and the clients are not so concerned, because they know that, well, gee, I rely on this for my income, so I'm still going to get the rents. If I don't own the actual building itself, I guess that's okay, as long as I can still get the rents. That would be a situation where you are putting an asset beyond their reach, but they still have the right to the income from it, and so...
They meaning Medicaid, the state?
No, they mean
the kids.
The client.
The client.
The client, okay.
Right, so the elders would create this irrevocable trust, transfer this rental property into the trust, keep in the trust, keep the right to receive back the income, the rents, and if we get past the 5 years, we're good to go.
What happens if you don't?
If you don't, then you will be disqualified for a certain period of time. Hopefully, you've set up the trust so that distributions of principal can be made to the kids, and perhaps they, out of the goodness of their hearts, might pay for skilled care during the period of disqualification.
And David, you were going to
Well,
add?
I was just going to say, so you set up that irrevocable trust, and by the very nature that it's irrevocable, it can be beyond your control. The children, oftentimes, if there are children, would be the beneficiaries, and so you try to set it up with enough leeway within the trust so that if it's possible and the 5 years haven't been met, that the children, and you always, Larry does this from the very beginning on any planning situation, is there are two things that go into a plan, the people and the property. And so let's talk about the people. Who are the people we can trust? Those are the ones you want in charge of those types of decision-making things. It's like people who come to us, and this is part of Medicaid planning too, that want to put their child's name on the house so that it doesn't pass through probate. And Larry can talk a little bit about what the state does. They don't disqualify you for a house, but when do they come back after that asset, if at all? And so a lot of times they want to use a life estate deed or a lady bird deed to do that, and you have to determine what is the bigger priority in your plan. The Medicaid issue, passing the property to your children, or is there an issue of locking yourself in with your children in some fashion?
And let's just go back for a second. In a previous session, we've talked about estate planning, and you can put together revocable trusts changing. We're talking about irrevocable here, which changes the nature of what someone can do with it during their lifetime. And do you want to expound upon that?
Well,
Because I just wanted to make sure you could say irrevocable versus irrevocable.
Very briefly, if it's irrevocable, you form it, you create it, it's got the rules that you gave to it when you created the trust, but you can't change those rules. A revocable trust, you reserve the right to make changes to the trust. And since you can do that, and Larry will correct me if I'm wrong, that doesn't help you with Medicaid planning because the state can say, make the changes, take the property back. So there's the problem.
So Larry, if the house is then put into an irrevocable trust, which you handle with Medicaid planning, and someone decides that they want to sell that, they could do that, but just have to keep the funds in the irrevocable trust? Or are they not allowed to even sell it? Or the other person who might be the beneficiary or have access to it, can they not change or sell that house if they wanted to?
So again, we're talking about not the primary residence, but rental property.
Rental.
Okay. So yeah, the trustee can do whatever they want to do with the assets inside the trust. And so if it's in everybody's best interest, we can sell the rental real estate. The proceeds from the sale now go back into the trust, and perhaps it's invested in some other kind of instrument that might generate income for the elder, because the elder has kept for himself right to all of the income that it produces. No access to principal, but income. Principal typically is made available to adult children who, again, we can use this as kind of a back door if we need to get, if we need to pay for privately for the care of the elder. The trust can distribute principal out to the adult children, and the adult children, if they're good doobies, will make sure that that mom's skilled nursing care bills get paid.
Do you want to touch upon that just a little bit more, if they're good doobies, because there's an issue about who you are entrusting this to without getting too detailed? What's the issue about it?
And as you talk about that, you can also use that as an explanation of why with a life estate as opposed to a ladybird deed, adding children can create complications.
So who's the good doobie? What's the story?
So let's say we have 3 children, and one of them is the trusted child, the good child, and has leadership ability over the other 2 children. So you name this child as the trustee. So we have centralized management, so this one good doobie gets to decide, gee, should we be selling the property or can we keep it? Is it generating enough income for mom? And the trust, if it's well drafted, can give this adult child discretion to distribute principal out to maybe just one of them, maybe to himself. If the other two can't be trusted, he could distribute principal out to himself, and then he could, again, circle back and make payments for mom. So, you know, in the trust, you want to draft as much flexibility as possible so that we can accomplish whatever it is that we need to in the trust. And this would be different from, say, deeding the rental property out to the 3 children, because now we've got 3 people who need to, if we do need to sell it, who need to decide who the realtor is going to be, what the price is going to be, who the buyer might, you know. We want centralized management. We want one person making the decisions.
And when we start talking about Medicaid trusts, as we are, there's also the topic of a life estate. Can you just touch on that, please?
Yes.
And the differences.
Yeah, sure. So there's a strategy called a life estate where you look at the real estate and it's owned, the ownership is measured by periods of time. There's the later and there's the now. The now is typically during the elder's life. And the later, called a remainder interest, is who owns it after the elder dies. With this arrangement, let me take a step back. So I said that they don't count the house when you go to apply for Medicaid. So let's say we have a single person. They don't count the house, but and the reason they don't count the house is that on the application, there's a question that says, do you intend to return home? And we always check off that box, yes, even though everybody knows you're never going home. The reason that Medicaid doesn't count the house is they would like you to go back home so that they don't have to pay for care in the nursing home. So they're not going to make you sell the house. But Medicaid is first in line at the probate court after the elder dies to get paid back, reimbursed for what they've paid out on behalf of the elder. But this reimbursement only happens in the probate context. If we can arrange to have the real estate owned in a way that will not go through the probate process, then we have effectively not had it count when the elder went into the facility, and also not be available when the elder passes, so not available for reimbursement. And the way that we set this up, again, is to create a life estate. So we give to mom, or mom owns the property. She gives to her children what's called the remainder interest. Their rights, while vested, don't really come into being until after mom has passed, because while she's alive, she has exclusive rights to use the home. And so with this arrangement, no trouble that the kids get themselves into, whether it's bad marriage, bad driving, bad luck, nothing that the trouble that the kids get themselves into can interfere with mom's use and enjoyment of the house. And when mom passes, her rights go away, and suddenly the kids own it all, and Medicaid is out of luck, essentially. One other thing, there's this concept, but if you do that, we now are looking at this 5-year look back, because when you apply, you say, did you give anything away? Yeah, I gave away that remainder interest to my kids. That has value, and that will be calculated to figure out some period of ineligibility. So the regulations allow what's called a ladybird deed, which if you insert a clause that say, even though I've done this, I'm going to reserve to myself the right to undo it, to take it back, to sell it to whomever I want. I get to keep all the proceeds, and I don't need you, my children, to agree to this. If there is such a clause in the deed, called a ladybird deed, believe it or not, Medicaid looks at this as, that's not a gift at all, because mom has the right to take it back. So if it's not a gift, there's no period of ineligibility, there's no disqualification. So we frequently will use these ladybird deeds. They're under review currently by the Medicaid folks. They want to come up with some new regulations that maybe rein this in a little bit.
So
But
good, quick question.
Just
Go ahead.
on that note, even with just estate planning, I find a lot of times where clients are insistent upon adding children to deeds, and I've seen the nightmares of doing that when they want to sell the property, they want to move to Florida, whatever it is that they want to do. The ladybird deed language leaves them with the ability to undo the mess that they might otherwise be creating, whether Medicaid changes the rules or not.
Right.
And a quick question as a follow-up to that. You mentioned the life estate. Does that work if there's a husband and wife and they deed this, or they set this up so that the children will have that remainder. It works with husband and wife, not just if mom is alone?
It does. They would essentially keep for themselves what's called a joint life estate. So
Okay.
it would be in place as long as either one of them was alive.
Okay. And while this isn't a math planning class, we talk about the possibility of gifting away or giving away the farm literally. Explain briefly the math or the tax consequences of giving it away versus some of these other alternatives. What might someone want to consider? And we know you have to go to either a tax lawyer or accountant or something to understand what this is fully, but the gist of how are you saving perhaps on some tax consequences with one opportunity versus another?
Well, there's a couple of different things. One of the things that comes to my mind immediately is the difference in a step-up in basis.
Yes.
Whereas if you gift property, the people who get the property get it at the value that you paid for it. So if it's that rental property, for example, if you give them the rental property that you bought for $50,000 that's now worth $500, when they sell it, they're paying capital gain on the difference, as opposed to if they got it through inheritance, the value would step up to whatever it was on the date of the death when they received it. So that's one issue. But as happens in these things, there are a lot of different things that come into play when people are determining what they need to do, which is the reason why when someone sees me or sees Larry, Larry will say to them, well, what's your goal? What do you want to accomplish here? What's the most important thing? Because it's almost like buying a boat. It's always a compromise. You can't get everything you want. I know that from experience.
So while, of course, people go online these days and can find out some information, this is what an estate plan is, this is what living wills are, this is how you might do some Medicaid planning, up to a certain point they could find out some details and some factoids. So are you saying that the difference is, for example, if someone goes to a lawyer, that you go through and methodically ask all of these questions about the who, what, and what are the special circumstances, because there's not a one cookie-cutter approach? Is that what the difference is?
Yeah, I think many of these things, clients occasionally will ask, can I do this myself? Do I need a lawyer? And, I'll say, yes, you can, but this is important stuff. And you want to do it once and do it right. And you want it to be effective in a crisis situation. So if you're on the steps of the nursing home, you want to make sure, and you want to have the peace of mind to know that, yes, it was done and done properly, and it will work.
And touch on, if you will, the other options that people discuss, like having an annuity or having insurance. How do those work? How do they come into play? And what are some of those pros and cons, if you would? Quick question, quick answer, hardly, but see what you can explore.
I can start with some of the options that you have, and many times we tell people they don't count, for example, the prepaid funeral bill. Right. So go out and make your plans now. Everyone's eventually going to need it anyway. That money comes out of your estate and goes into a plan that gets that bill paid for. So if there are two of you, it's up to what, like $20,000, $10,000 each? Sure. So there's some money saved there. Larry can speak to some of the ways you can take money and annuitize it, for example.
Sure. Still workable. You can still use annuities, correct?
You can, but they're a specific type of annuity called Medicaid qualifying annuities. And this has to do with the distinction between assets and income. Here's what I mean by that. You have $100,000 in the bank. You don't qualify for Medicaid because the rules say you can only have $4,000. If later today you take that $100,000 and you purchase a Medicaid qualifying annuity, you have just turned this asset into a stream of income. So with this, beginning next month, you will start receiving a check from the annuity company, and Medicaid now says, well, you need to use your income to pay the first dollars of your nursing home care. Medicaid basically makes up the difference between what you pay in and what the nursing home is allowed to charge. So if you have this $100,000 and you purchase an annuity that gives you $2,000 a month, you need to take that $2,000 and give it to the nursing home. But the $100,000 as a countable asset is gone. Now what you have is a right to go to the mailbox for the next 3 or 4 years, whatever it is, and get this check for $2,000. That's income. It's not an asset. There is an income test, but as long as your income is less than it costs to pay for the monthly nursing home, you're good to go. It's a little more complicated than that, but for our purposes.
If you have a husband and a wife, and say the husband's the one who's targeted to go to the nursing home, does the wife get that income stream, or does the husband, and how do you want to explain
Yeah, sure.
that?
Absolutely. In fact, one of the strategies, as I said, so let's say that we had husband and wife, and they had roughly $230,000. Again, we divide it in half. Husband's in the nursing home?
Or getting ready to, or however you want to call it.
So the wife, we divide it in half. Wife has $115,000. That's half of what they have. Husband now has $115,000, and he's not going to qualify until he has only $4,000. So this is painting with a very broad brush, we take $111,000, $112,000 and purchase an annuity, and we say that the income is payable to the wife. So we have now taken 100 and whatever I said off the table. He's now $112,000 off the table. He has $4,000. He's good to go. And she all of a sudden now has the right to receive this stream of income, and that would work. Just one of the things you have to do is you have to name the state of Rhode Island as the beneficiary of this annuity. So if the wife dies before she receives all of her monthly payments, whatever's left in the annuity gets paid to the state of Rhode Island to reimburse it for what it has paid out on the husband's behalf. So typically you'll want to pick a kind of a short window of time that she receives the payments. Most companies will sell 3-year annuities as the shortest amount of time. If she receives all of the payments over the 3 years and lives through that, none of that has to be used to be paid back.
And suppose it happened the other way. The gentleman was the one who buys the annuity for her. Suppose instead she's the one that ends up with the nursing home problem. That's a gamble which you lost?
Yeah.
Okay.
That becomes income that's
Exactly.
payable for the nursing home.
Exactly.
And what about outright insurance for Medicaid?
Long-term care insurance.
Yes.
Well,
Short time.
one of the things we talked about was that long-term care insurance is a benefit that you'd have to buy at a pretty young age to make it affordable, number one. And number two, when we try to sell it to people, they don't think about going in, but everyone's going to die, so they do now have a platform where they sell life insurance that has a long-term care component to you. The cash value can come out and be used for long-term care, nursing home care.
And we assume that the quality of care, whether you paid outright as a private pay person, you had the money, you could pay outright for it, is the quality of care going to be equal to that of a Medicaid planned person who is going into a nursing home?
Yes, it is.
Okay.
Count on that. The only thing that you might want to be aware of is you don't want to show up at the nursing home saying, I am Medicaid ready, I got nothing, let's find me a nice bed. They will tell you, they're not supposed to, but they will say, gee, we don't have any beds this week, come back later on. So you want to have some money to pay privately early on so you can get yourself into the facility of your choice.
That's good to know. A different kind of strategy, but certainly another worthwhile one.
Sure.
And you, like Larry's saying, you want to be able to pick the place you want to be. Once you're there, then you can go through the process of qualifying for Medicaid.
Good. Sure. Larry and David, thank you. Hopefully we've helped you become more aware of the questions that you want to ask in your own planning. Stay tuned to the legal matters. Our discussion of it will continue, and you would care about it. We hope we've helped you deal with these issues. Thank you, and stay tuned. Legal matters discussions will continue.